Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. The DOL proposes a joint employer rule. The Department of Labor announced a proposed rule for determining joint employer liability. New in this rule, it determines joint employer status not only under the Fair Labor Standards Act, but also under the Family and Medical Leave Act and the Migrant and Seasonal Agricultural Worker Protection Act. The proposed rule is primarily a return to 2020 joint employment standards, with some clarifications to address circuit court rulings. The rule reinstates the economic realities test, focusing primarily on direct exercised control, but it does leave room for consideration of reserve control that has not been exercised by the employer. The rule also reopens the door to indirect control using the pre-2020 sufficiently associated standard, but includes new guidance stating that certain relationships, such as sharing the same vendor or a franchisee relationship, are not on their own sufficient. Employers with subcontractors, franchises, or subsidiaries could be particularly affected by the DOL's proposed rule. The comment period will close June 22nd. The Fifth Circuit denies overtime pay despite worker misclassification. The Circuit Court upheld a jury verdict finding a worker who was misclassified as an independent contractor was not entitled to overtime pay. The court's reasoning centered on a key FLSA requirement. An employer is only liable for overtime if it knew the employee was working outside of regular hours. In this case, the employee who was misclassified was not required to track or report his time. Thus, the employer had no knowledge of any overtime worked. Finally this week, two compliance actions of note for employers. Immigration and Customs Enforcement released a fact sheet reclassifying Form I-9 errors that were previously considered technical or procedural failures, such as failing to date Section 1, failing to print the employer's complete name and title in Section 2, or forgetting to sign and date the certification. Almost any omission or mistake on these forms will now be considered substantive errors. Substantive errors cannot be corrected and subject employers to potentially hefty fines. Employers should review and audit their documents, processes, and procedures that could be affected by this change. And the DOJ has extended compliance deadlines for its 2024 ADA Title II Web Accessibility Rule for state and local governments. However, employers should note that healthcare organizations receiving HHS funding must still comply with HHS's web and digital accessibility standards by next Monday, May 11th. The extension does not apply to those organizations. That's it for this week. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.